Welcome. We're glad you're here with us today. This is the nuts and bolts of a 363 motion, which is episode 1 of the second series of Financial Poises, the nuts and bolts of chapter 11. You can read more about the series on slides 7 through 9. Our panelists today, in alphabetical order, are Matt Christensen of Johnson May, Eric Fromay of Arent Fox Schiff, and Ashley Jericho of McDonald Hopkins. I'm Matt Grimshaw. You can see our names on slide 6 and our bios on slides 30 through 33. This is not intended to be an infomercial, so you don't have to listen to me read our bios. You're capable of doing so. If you want more information about us, take a look at our bio slides. Before we begin, we've got a few housekeeping matters to cover. First, I'll try to call your attention to the slides that are relevant to what we're discussing so that you can take notes if you want to. If you're listening but not looking at the slides, don't worry, they're not critical to what we're discussing. Second, a big thank you to our co-producers, the National Law Review and Daily DAC. You can read more about them at the beginning of our slide deck. Financial Poises webinars are supported by our sponsors. The sponsor for today's webinar is Max Asset. You can read more about Max Asset on slide 4 if you'd like. Finally, the last housekeeping matter is a customary disclaimer. While we are all lawyers, we are not your lawyer. What we offer is information today for your general education. As you are not our clients, nothing we say here today is intended for you to act upon without doing your own due diligence, including obtaining the appropriate advice from someone that actually does represent you. Without further ado, let's simply jump in. Matt, what is Section 363 of the Bankruptcy Code and why is it needed? Slide 23 quotes some of the language, but what's this all about?
So generally speaking, in a Chapter 11 case, for instance, you've got a debtor who's operating, they're continuing to provide services, provide products, whatever it is they do. And there's provisions of the code that allow them to continue operating in the ordinary course of their business. Section 363 comes in when they need to do something outside the ordinary course of their business. Then it outlines you need court approval to do something extraordinary. And so whether you're let's say you're a construction company that's constructing things, and in the process of doing that, you regularly buy materials from a wood supplier, something like that. That's an ordinary course transaction. But if you want to sell one of your large pieces of equipment, that may be something that isn't an ordinary course transaction. The line for ordinary course sometimes gets a little fuzzy. There could be an argument that a construction company does regularly sell and buy equipment. And so then it becomes, okay, what's the scope of the thing that you're selling? So, but 363 really comes in when I need to do something as the debtor, or in a Chapter 7 case, the trustee, that's outside the ordinary course of the operating business of that company.
Thank you. Ordinary course seems to be a pretty broad statement there, Matt. Can you give us any guidance as to what actually gets looked at in figuring out what is or is not ordinary course?
So the first thing, you're going to look at the debtor company, right? What is it they do? If they've had historically, you may look at historic financials for that company. What have they bought and sold in the past? You may look at sort of moving forward. What's the operating plan going to be? It may be that, for instance, they've got 3 different lines of business, that one of them is not going to be operating moving forward. So the sale of the assets related to that business that are not going to be operating, I would say that's an outside the ordinary course transaction. But you're looking at sort of historically, what's the debtor done? What's the potential bankruptcy plan going to be? And that's where, sometimes it does get fuzzy. We have a large dairy case right now where you would think a dairy doesn't necessarily regularly buy and sell equipment and tractors, but at the size that this dairy is, they do regularly buy and sell tractors. And so there's an argument that that buying and selling of tractors is ordinary course for this level of debtor. But if you have a smaller dairy that has 2 or 3 tractors that they run till they're dead, buying and selling a tractor is outside the ordinary course for that small dairy. So it's really a very fact intensive look, and that's something that a creditor may look at and challenge. Hey, in order to sell this or buy this, you've got to have court approval, and so you start that process of getting court approval to do that transaction.
Eric, I know these sorts of sales, sorts of transactions are pretty popular in Chapter 11. Why is that?
Well, a 363 sale is really a value buying opportunity for buyers, for companies, whether they are a strategic buyer or a financial buyer. So you have an opportunity to buy a distressed business, and that usually comes up during an economic downturn or a company is unable to restructure their finances. And it gives a strategic party an opportunity to step in and get value. In addition to that value, the 363 sale provides a lot of benefits, right? It allows the buyer to acquire the assets free and clear of liabilities, liens, claims, or interests. The code used interests. I added interest is a very broad term and includes liens and claims. It reduces or eliminates successor liability risk. It can reduce fraudulent transfer risk. It allows the buyer to cherry pick what contracts it wants to keep and what it doesn't, what employees it wants to keep. It gives them some good faith purchaser protections. And it gives advantages to the seller as well. The company that's in trouble now, they don't need stockholder approval. And they get the protection of the bankruptcy court. The officers and directors of a company that's going to sell, they need to maximize value. And that's standard corporate law. Well, that's the bankruptcy process. The whole process in the 360 sale process is to maximize value. And then once that sale process goes through, an independent fact finder, the bankruptcy judge, subject to objections by all parties, will make a finding that this was the maximum value, which protects the sellers. Those are some real benefits that give the buyers opportunities to step in and get assets somewhat at a discount. Even though they're maximizing value, they're buying something that's in distress, and they're taking a bet that they're going to be able to turn it around. There are negatives. It's not all champagne and roses in a 363 sale. And some buyers don't like a 363 sale because it opens up the process to competitive bidding. And in a private sale, they can step in and there's no other parties involved. And they want to secure that. And they want to make sure they get, hey, I think I'm going to spend $10 million for the asset, but now I have a competitive bidder. I end up getting it, but now I spent $12 million. And I didn't really want it. I wish I could have got it for 10. So they like to eliminate that. And then there's always the risks of a bankruptcy filing. A bankruptcy filing can disrupt the business. And there's all kinds of tactics to address these issues, the negatives to a bankruptcy sale. And that's why you need somebody who's experienced in that process to guide the debtor and the company through that, as well as the buyer oftentimes. But some of these things can be increased costs of the transaction because you have the court process. Employees may leave, customers may leave. You don't know it depends on the type of business. Certain businesses, they withstand a bankruptcy filing and they don't lose really anything. Some enter in bankruptcy, and I did one where it was an international business, and all the professionals were convinced that, hey, when this company goes in, bankruptcy won't have impacted at all. But when we talked to the CFO, he said, "Oh no, we're going to be in big trouble," and that he was exactly right. Every competitor used the bankruptcy as a negative on every new potential deal they tried to do, whether it was selling their product or buying raw materials to produce their product. And it really impacted the business. And it drove down the purchase price, by the way, as well. So you have to really look at that, and that could be a negative to the sale as well. But those are some of the benefits and positives of a 363 sale.
Thanks. Hey, Ashley, I think I heard Eric say that you can shed or potentially shed successor liability and a bunch of other sorts of liabilities in connection with the 363 sale. Seems to me that notice would play a pretty key part of that. Can you talk to us about what sort of notice is required in connection with these sorts of sales?
Yeah, so notice may not be, the most interesting aspect of 363 sales, but it is definitely one of the more important aspects to make sure that the sale process is successful and that there are no issues on the back end, like you said, with successor liability or new claimants coming forward and asserting, rights to certain assets. So, the first type of notice that's typically provided in a sale process is with respect to the bidding procedures motion. The bidding procedures motion, there is a whole other, I believe there's a whole other portion of Financial Poise webinars on this topic, so I won't go too in depth. But that is essentially the first opportunity for everybody to understand that there is going to be a sale process for the court to review and approve the stalking horse purchaser, sale timelines, assumption and assignment / cure notices, and to get that sale hearing on the docket. So that's kind of the first step. For the actual sale motion itself, the debtor must give all creditors at least 21 days notice of the sale hearing for the approval of the sale process. This requirement is set forth in section 363(b)(1) of the Bankruptcy Code and in Federal Rule of Bankruptcy Procedure 2002(2). So, the form of the notice is typically approved as part of the bidding procedures order, and the form of any assumption and assignment / cure notice is usually also approved at that stage, so that there is a guided way to provide these notices to all of the required parties. And again, that notice needs to be to all creditors. If the notice is not provided to all creditors and there is a defective notice, that can have huge consequences to the outcome of the sales process and ultimately lead to issues being raised either by lien holders or tort claimants, environmental claimants, all of these sorts of parties, if they are not provided adequate notice, can kind of raise their heads later and try to argue that either their liens still exist, or their claims still exist, or their claims should be able to be asserted against the successor buyer.
So I think what you're saying is the seller may be the one given the notice, but if they screw it up, whoever buys this may be stuck with the result. Is that
That's right.
that might be problematic?
Yeah, the seller is stuck with a defective notice. So just from a practical perspective, one of the things a buyer may want to do or should do is make sure that they are reviewing the service list ahead of time, making sure that all of the parties are included on that service list. And, you know, taking those steps proactively to make sure that there aren't issues on the back end. And, you know, sometimes there are third parties involved, like claims agents in bigger cases, who are actually effectuating the service. So, you know, as buyer's counsel, I would want to be looking at the service plan before the service, making sure all the parties are on it. And then when that certificate of service hits the docket, I would also want to be reviewing that to make sure the services actually went out as they should have to all required parties.
That makes sense.
Yeah.
You know, Matt, and Ashley, one of the first cases I ever had involved this exact issue where a sale had occurred and neighbors of the property that was purchased filed claims. The property purchase was a manufacturing facility. I think they made like skis and they used a chemical process. And they said they didn't get notice. I think they had, if I'm recalling, they had what we call publication notice. It was in the paper, but they were neighbors. And the court said, well, they were neighbors and they were known to you. You should have mailed it to them. And then the buyer was stuck with those claims. So the notice was really important. And the buyer approved the notice of just publication notice, to your point, Ashley.
Yeah, and I'll also note another thing where this comes up talking about publication notice is where you have tort liability or, you know, mass tort situations where there is a publication notice that is put out, you know, in papers or even through, you know, television advertisements to make sure that the notice is being disseminated as widely as possible. But, you know, if a party is known and they can come in and make that argument that they should have received notice directly through mailing or otherwise, it can lead to issues. So this is a very important, you know, issue both from the seller, but especially the buyer side.
All right. Hey, Matt, this really is a nuts and bolts program. So how about you talk with us about the nuts and bolts of a sale process, one that's outside the ordinary course of business.
Yeah, so obviously you have to have court approval, so you got to file something with the court. That can be a simple process or a very complex process, depending on what's being sold, what the market reach is for that sort of thing. Typically, you're going to want to hire some kind of marketing professional, whether it's a realtor for real estate or a business broker or an investment banker, or whatever the scope of the asset is that's being sold. So the first step is really get that person employed, get the application of employee filed, and then in conjunction with that person, whoever it is, you'll work out, okay, what's the sale timeline? Does this need to be a really quick process because the assets are dissipating, or does it, you know, do we have some time to go through a typical marketing and some advertising and this sort of thing? Whatever that marketing process is, may or may not be something that you get the court to approve. There may be a bid procedure motion that gets filed to get court approval of the process. If it's a sort of smaller asset that you're just doing an auction for, you know, the auction itself is probably the process. You don't necessarily need a court approval for how to run an auction. Auctioneers usually tend to do that, and my experience is they're remarkably optimistic about their ability to sell anything. So the marketing process, you know, it depends on the scope of what you're selling. If you got a piece of real estate, maybe it's, you know, your realtor is putting it on a listing and it's a local thing. I've had some cases where there's a lot of heavy equipment, and so that ends up being sort of a national marketing push where there's listservs that advertisement gets posted on. Maybe there's industry events that it goes to, or a marketing equipment journal that it gets published in. So it really depends on the scope of the what it is that's being sold, and the type of sale is something that you'll have to decide too. Is it sort of an open auction? Is it a live auction? Is it an online auction? Are you going to sort of chill some bidding if you do a live auction, just because parties may have to travel to where you're at? So is it then better to do a online auction? Also, is it if you've got multiple things being sold, are you setting it up where it's a sale of everything at once, or do you have separate lots that are being sort of packaged together? I had a case once where we represented a electrical company, that the debtor was a big project owner. The project had sort of stalled halfway through. Millions of dollars were owed to subcontractors, including my client, and they ended up doing an online auction of literally everything that they found at the site where this thing was happening. And my client got on and was looking at pictures from the auction and found several tool sets that were stamped with my client's name. They were their tools that they were selling at this auction. And they came running to us and were like, hey, you need to get in and, object to the sale of our stuff. And I'm like, look, the tool set that they're selling is worth like $100. You're gonna pay me $1,000 to try and stop them from selling that little thing. So that kind of goes back to the notice thing, I guess. Make sure what's being sold is actually the debtor's stuff to sell, and don't just grab whatever's there and assume that it's the debtor's. So, but the fact that that was open was what allowed my clients to see that, hey, they're selling our things, and ultimately they decided not to do anything about it.
So, quick question. Some of these marketing processes that I'm familiar with can take a very long time. What drives the decision about how long to spend?
Some of it is sort of how quickly does the debtor need to divest itself of those assets. If it's I'll give you an example. We have another case I was involved in where the debtor's assets were live animals, and they didn't have the funds to continue to feed and care for those animals. So in that case, we wanted a very quick auction process or sale process, just because, look, Judge, think the assets are going to start to die, and then we'll have a whole different problem on our hands of cleanup. And so that's one example where, look, at the asset that's being sold may drive how quickly the sale process is. If it's like I mentioned, the construction company before that's just got some extra equipment that needs to liquidate, it doesn't need that stuff. The banks aren't necessarily clamoring for stay relief to go liquidate the things. Then you may be able to take more time and do that more extended marketing. So the biggest thing is, and this is the perfect attorney answer, I guess, is it depends, right? Depends on what the asset is and how much the debtor can continue to operate without having that asset available.
Fair enough. Eric, the slides 12 through 15 mention that the 363 process often uses a stalking horse bid. What's a stalking horse bid? And from a seller's perspective, why would you want one?
Yeah, sure. I think, when we're talking about this 363 sale process, I'm going to take one step back to introduce the stalking horse bidder. Matt just described, like, hey, we got approval to do a live auction. We go through and sell tools and equipment, and I've done those, do them online. They're super fun. Or there's one where you're just selling a piece of real property. You hire a broker, you go find somebody, and that initial buyer, that initial bidder, we'll call the stalking horse bidder. There's another way we'll do it, is that this will be the operating business, and that initial bidder will be the stalking horse bidder. So think of the stalking horse bidder as the initial bidder. Well, what's the advantage and disadvantage of being a stalking horse bidder? Well, you're the first one in, so you get to set the price, you get to set the terms, you get to set you actually get something what we call a breakup fee, which is if you're the losing bidder, you can get a fee. And then you can set the initial overbid terms. Anybody who wants to come in and bid more, they can, they have to at least bid your breakup fee and your, and give the estate some profit. You might get some expense reimbursement. You get to control the process, which is a huge advantage. You can also control it as the stalking horse bidder by being the lender. So when Matt was talking about what drives the process, and another factor that drives the process is who the lender is. And the secured lender might be the initial bidder, and the secured lender might say, hey, I'm only willing to give the debtor X amount of dollars, 90 days to operate, and this thing has to be sold, right? The other factor will be the court. Some judges say, look, you got to at least market this thing for 90 days. Others will be, hey, 30 days is just fine. So you need to know your judge and how fast you can go. But the other factor that'll contribute to the speed is the stalking horse bidder. The stalking horse bidder may say, look, I'm willing to do this, but it's got to close by X date for these reasons, right? Now, there are risks associated with being the stalking horse bidder.
Eric, real quick, you described the benefits from being the stalking horse. Is there a benefit from the seller's perspective to having one?
Yeah, and so Matt's team up for my favorite line in bankruptcy is that once you become the stalking horse bidder, another term is you're the tethered goat. You lock in a buyer, right? So they can't get away. So that's a negative to being a stalking horse bidder. Is like, oh, well, what if I change my mind? Well, you're locked in. Now there could be what they call a reverse breakup fee, where you get out and you want to get out and you have to pay the estate some money, and you can negotiate that up front. There might be some massively changed circumstances, which I've used in some cases, whether I might have been walking on thin ice and making those arguments, but I use those arguments to get a better deal, right? And so you say, hey, look, we're going to leave because some changed circumstances. I'm the tethered goat, but I'm like gnawing at the tether pretty hard. And so that could be a negative to the being the stalking horse bidder. It's also a bit of an illusory contract, right? Because you're the stalking horse bidder, you have a contract, but the debtor really hasn't signed it. I mean, if he signed it, he can't go through with it because he needs bankruptcy court approval. So one of my favorite cases I ever did was a sale of real property. I walked in with a stalking horse bidder to buy a flagpole lot, which looks like a flagpole, and we actually did the auction in court with the judge, and an overbidder showed up, and we went back and forth for half an hour going over this lot. And the stalking horse bidder won, but he's paid hundreds and hundreds of thousands of dollars more for a vacant lot in Menlo Park. He really wanted it, but but he could have lost it, right? So you could just go through and lose and go to somebody else. And that's where another negative is. You spent all this money, right, to do your due diligence, to set up the contract, and somebody else can come in and go, yeah, that was great due diligence. I like all this stuff. I like all those contracts you identified you're going to assume. I like everything you did. I'm going to do everything, but I'm going to pay $10 more. And that could happen as late as the hearing to approve the sale. So you're always telling your stalking horse bidder, hey, if somebody comes in and offers more money, right? So I was in a case with skilled nursing facilities where the stalking horse bidder was a public entity, and they had the highest bid, but somebody else came in and offered cash, and they put the cash like $33 million, I think it was, in their attorney's trust fund account. So the judge is like, well, I got $33 million cash. The other party said, oh, well, we can overbid that, but we need to go get our board's approval. And the judge is like, I can't wait for that, and took the $33 million cash, and they lost out on that. So that's where they did all their due diligence and they lost on it. So that could be a negative to being a stalking horse bidder. They got their breakup fee, but small condolence in that case.
Hey, Ashley, Eric's mentioned a breakup fee a couple of times. Can you describe what that is and how that kind of helps protect a stalking horse bidder? I think you're on mute.
Yep, so the breakup fee is essentially a fixed amount that is payable to the stalking horse if the sale, is made to another bidder after the process completes. So, this amount is used to compensate the stalking horse bidder for any lost opportunity it may incur, as it's acting as the stalking horse purchaser through the sale process. Generally speaking, this breakup fee is usually between 2 and 4% of the overall purchase price, but that is, an issue where various parties, including the U.S. trustee or the unsecured creditors committee, can come in and raise some issues if they think that, the stalking horse is maybe reaching a little too high on the breakup fees. Usually I've seen it more around the 3% range. But again, that's dependent on the size of the deal, the jurisdiction you're in, the court you're in, the judge you're in front of, and the other bid protections that the stalking horse is requesting to act as a stalking horse. Some other ones I know he also quickly mentioned expense reimbursement. This amount is usually to reimburse the stalking horse for its actual and out-of-pocket expenses for the diligence process, including attorney's fees, other professional fees, to make sure the stalking horse is able to recoup some of those expenses if they are not ultimately the winning bidder. And again, this is dependent upon the complexity and the size of the case, how much the stalking horse can, or the debtors can get approved for the stalking horse at the bid procedures hearing and in the bid procedures for them.
So actually, I got a follow up, but I mean, it's not exactly related, but it is in a way. And that is, if I'm dealing with a secured lender, can a secured lender be a stalking horse bidder because they might have a credit bid right or something else? I mean, how does that work?
Yeah, so a secured lender can actually act as a stalking horse. However, when the secured lender is the stalking horse, it can sometimes bring a little bit of additional scrutiny because it discourages other potential bidders from bidding on the assets due to the credit bidding implications. So a secured lender who's acting as the stalking horse, they have the ability to credit bid up to the amount of their secured claim. So, where they have that ability to raise the amount, far and above what other potential bidders may be willing to buy the assets for, it does sometimes have a chilling effect. And it could lead to a situation where the assets are ultimately sold to the secured lender solely in exchange for wiping out the secured lender's claim, and there's actually no monetary value brought into the estate for distribution to any of the other creditors or stakeholders.
So in some ways, it could just end up being akin to a foreclosure.
Yeah, I would chime in on that, though. Sorry to interrupt. I think you have to be careful in those situations. And maybe this is where Matt was going, in that if there's no money coming to the estate, or Ashley, that you need to cover the cost of going through the bankruptcy process. And some bankruptcy judges insist on it. So you're going to have to pay the administrative fees, at least to some extent. And that's a negotiated process. I've been involved in cases where that's exactly as Ashley described, where when the secured lenders, the stalking horse bidder, they're the winning bidder. No real money came to the estate, but the secured lender negotiated with the debtors professionals about what their fees were going to be. And then they fought about it afterwards, fee objections and that kind of stuff. And I was involved in that back end portion of it. And that can be very, very intense litigation. Let's put it that way. Nobody likes to pay more than they want than they thought they were going to pay.
But
Yeah.
sorry, the other scenario I've seen where that works too is if there's multiple assets that the debtor owns, but not all of them are part of the sale. And so that creditor is getting paid from the sale of, say, the real property and waiving any further claim, which frees up all of the equipment. So that there is some benefit still left for the bankruptcy estate of losing that claim, and the security interest in those other things. So that's a situation I've seen where that still worked, even though the estate wasn't receiving anything monetarily from that sale, but it still was approved because there were other benefits to the estate.
Yeah, and just to piggyback on that too, like you'll see sometimes where it is the situation that there isn't going to be money coming in from, you know, that
process, but this aspect of it is an interesting point where you bring in the secured lender, and maybe it's the secured lender has to make a decision. Do I want to take over this business? You know, because I'm going to be the stock market bidder, and so I'm.
It was a really good thought. I was waiting for him to say.
I'm afraid he froze. Ashley, I know you were kind of on the same page as Eric as you guys were talking about the same sorts of things. Do you want to pick up, because it looks like Eric froze, and I hope we didn't lose him.
Yeah, one of the things I just wanted to mention is, you know, when you find yourself in that situation where the secured lender is the winning bidder and there are no assets coming in from that, I mean, no funds coming in from the purchase of a bucket of assets, one of the things you will see a lot of the times at the sale hearing is objections by, you know, 503b9 claimants or other potential administrative claimants, making sure that the freight of the case is going to end up being paid and that there isn't going to be, you know, essentially an all out or wholesale loss for everybody else in the case.
And Eric's back. Thanks for jumping back in. I know that's where you were headed, because that's exactly where the direction you were going, Eric. And so it sounds to me like that's just one more thing that if you're setting up a sale from either side as the buyer or the seller, you've got to make sure that becomes part of the negotiation. Will there be money available? And if not, how are fees going to get taken care of, or you're going to end up with a whole bunch of objections?
Yeah, so like Ashley's point and your point, Matt, is that we've been in cases where our 503b9 claims is a great example, is that the debtor is required to, and the secured lender, or the DIP lender, in this case, the demonstration lender, to identify the amount of, or an estimated amount of 503b9 claims and literally put that aside in escrow to make sure they get paid as part of the process. If you don't, you're not going to get approval. And I've seen that in multiple jurisdictions. That's just not, it's all over the country I've seen.
Yeah, and I'll point out too that just from, you know, an attorney fee administrative claim perspective, that's why you oftentimes see the carve out in the DIP ahead of time to make sure, you know, the professionals are always going to making sure they get paid.
Right. Hey, Matt, you started talking about a few minutes ago a case where, you know, a lender may have had a lien on multiple assets. They sold one, took their payment from that, and freed up others. What happens if you get multiple bidders for the same asset? How does that all shake out?
So as the seller, you go out and celebrate because that's what you want to have happen, right? That's going to drive the price up. So,
all right.
It depends on the bid process that you set up, right? If it's the same asset and it's just money, and I've got one bid that's 100,000 and another bid that's 105,000, that's really easy to evaluate. But if it's a more complicated sale, you know, it may be that you had an auction set up and you got one bid for everything in the auction and then a whole bunch of other smaller bids. And maybe those smaller bids as a whole, for some reason, make up more value than the single large bid. So you've got to compare the offers. We also had a sale once where the offers, there were multiple offers, but it was for an ongoing business, a going concern business. And one of the offers was basically just, hey, we want all the assets. Another offer was, we want all the assets, but we're also going to continue to employ all your employees. And so there was some benefit seen from that, even though the asset price was a little bit lower. And so you've really got to, you try and set up the sale as much as you can to where you're comparing apples and apples. But sometimes it happens that, you've got either apples and oranges or Golden Delicious versus Granny Smith, and which one's better, right? So you've got to be able to evaluate that and have some process in place to do it. And then whatever process you set up, at some point you got to have a deadline, right? Like, hey, this is, I need all your offers by this date at this time. If you're having sort of a live auction or a court hearing, then of course that's the time, show up and, we'll stay here for an hour or 2, 3, 10 hours if we need to, if this thing's still going. So you want to have some sort of end date where, look, at some point we've got to actually close on this sale, which means we need people to come ready to close.
Well, to your point, Matt, yeah, you want an end date, but you also want the highest best bid. And I've been in auctions that have lasted many days. I've slept in the conference room, right? I've gone home, showered, and come back. We've eaten there for days until the deal was done. Other times, like I said, it's the courthouse and it was fun for half an hour. But yeah, you have to, and comparing those bids became extremely complicated. It required not just the lawyers, but all the financial advisors and the debtor to sit down and compare and then negotiate with the other parties, like the committee counsel and their advisors, going, hey, do you agree with our comparison? Are you going to object? And that stretches out the process, because sometimes it takes hours to figure out, whether you're looking at a Granny Smith or a Golden Delicious or not.
And I think the thing to remember too is whatever you end up with still has to be approved by the court. And so whatever your analysis is, the UCC may agree with it. Everybody may be on board, hey, this is the best bid. And then you walk into that courtroom and the judge says, I don't think so. I think you could do better. Go back out and keep going. And so you've got that aspect to it as well. I've had ones where we show up to the set, the auction was done, everything was completed. We show up to the sale hearing to get it approved, and some other party shows up. It's like, hey, judge, I'll pay more for that asset than what they're asking you to approve. And I don't know any judge that's going to sit there and say, well, too late, you didn't show up on time, right? We'll continue the hearing if we need to. Go out in the hall and talk. And so the judge ultimately has the last word, and if he wants parties to take more time, parties are going to take more time.
Hey, Ashley, I know this got mentioned a little bit by Matt and Eric, but I mean, can bidders team up to try and buy assets as a group, and is there collusion that gets involved in that, and how does that all work?
Yeah, so in some circumstances, bidders can actually come together and, team up to make an offer to acquire, a business as a going concern, or acquire, certain buckets of assets. If they are going to team up, typically that is done via a joint venture setup, where the parties are pooling their assets, pooling their expertise, and they can justify some reason for, making the offer together, whether, the business is too complex or difficult to run for just one of the parties, but together they think they might be able to pull it off. The one thing that, you would want to make sure that you're doing if you're going to team up to bid is to be really transparent about the joint bidding. And that is necessary so that you can avoid any accusations of collusion. Transparency is the key here. Disclose the joint venture and joint bidding as quickly and early in the process as possible. And, ultimately what it's going to come down to is like Matt and Eric were discussing earlier, is the court is ultimately going to review the sale process and the auction at the sale hearing and, determine whether, the offer was made in good faith and the sale process is being, the sale is being done on the highest and best terms. So, the
So
judge.
what you're saying is collusion may be okay as long as you tell people you're colluding.
Well, it's not necessarily collusion, and you often see this in the proofs that are put forward at a sale hearing where the debtors will, put forward a declaration or put somebody on the stand to talk about, the proposed purchaser, how they came to that bid being the highest and best at auction, why they believe it is the highest and best. And, they're putting that out in the open to essentially make the best case possible. If there is actual collusion and there is, some sort of shady business going on, usually that would be ferreted out. And there are certain consequences built into the bankruptcy code, including compensatory and punitive damages that can be put in place as penalties where there is some sort of shady deal that has been found.
And so I take it that's why you would want to be transparent is, you may be able to team up with somebody else, but tell folks you're doing it. Otherwise you might get into real trouble.
Yeah, and maybe have in your back pocket some explanation for why this is going to benefit the stakeholders and be a benefit ultimately, to the businesses of going concern, saving jobs, doing all of those good things that are often forming the basis for a sale and bankruptcy.
That makes sense. Hey, Matt, how do we go about actually getting a 363 motion approved? I mean, what's the procedure to get the judge to bless it?
So usually when you filed the motion, you file the motion for approval of the sale. In that motion, you're sort of, let me back up. If you've previously done a bid procedure motion, then you've sort of got the timeline in place already because of that bid procedure motion. Then if you say you've got a stalking horse bidder, right? Then you're filing the motion to approve the sale with the stalking horse bidder as the potential buyer, unless there's overbids at the auction that's going to happen pursuant to the bid procedure process. But at some point you have a court hearing scheduled. Ideally, the court hearing is scheduled as close to the close of the sale, or not the close, but the end of the bidding process as possible. Mostly just so you can get in there quickly and avoid potential other parties showing up in that interim time and get the court approval so you can then close as soon as possible. And then at that court hearing, you're presenting to the judge, here's the bids that we received. Here's why we think this is the highest and best bid. Other parties can chime in. That's the hearing where you may have some mystery party show up and say they're ready to pay 33 million cash for the thing. But at some point you're going before that judge, and ideally the process has already been known to parties from the very beginning, so that you can get there and the hearing goes relatively smoothly because the process has been complied with. Everybody knows what the highest and best offer is. That said, you'll have there's a very good possibility you'll have some kind of contested hearing.
Hey, Eric, what happens if you if a buyer wants to purchase a valuable contract? Think, for example, a below market lease. What are the issues that they've got to deal with in that situation?
Yeah, I'll add to real quick to Matt's point, though. It's the Yogi Berra quote that it's never over till it's over, and it's never over until the debtor gets the money in the bank account. So that you
Fair enough.
you got the bankruptcy court approval order, it's signed, everybody's got it on, and the judge signs it, and you're like, okay, where's the money? But really, this is one of the powerful things in the 363 sale process and the bankruptcy process is you get to decide what contracts you want to keep and which ones you want to get rid of. And you can, and that's really driven by Section 365 of the Bankruptcy Code. And the debtor can assume any contract and then assign it. There are some limitations. And if there's a breach of the contract, the debtor just has to assume, cure the breach. Some breaches can be non-curable. It's like maybe like a historical breach that just can never be fixed. Most of the time, those breaches are curable through finance, through money, and the buyer will pony up the money. And there's a process you go through in that bid, in the sale process. You build it into your contract and your bid procedures where you give notice to all the parties you're going to assume, all the contracts you're going to assume, and then those other contracting parties get to submit, hey, look, you owe you say you owe us $100, but it's really $150. And you go, okay, and you resolve that. And there's a resolution process, and you can use the bankruptcy court to resolve that process if you object to it, and that'll be part of an objection process. But you're, as the buyer, obligated to fix that. You can also not assume contracts and get rid of ones that you consider unprofitable. The real restriction comes up in intellectual property licenses. Those are tricky, and Section 365N is your guidepost there. You look at 365N, and it'll let you know what you can in the process. So if the debtor is, frankly, it's very tricky, and I think the slide actually says it's tricky, and I always find it tricky. But if the debtor you have to decide whether the debtor is the licensor or the licensee. The debtor is the licensor, then the licensee gets to choose what happens to the contract. And that's set forth in 365N, right? So you can treat it as terminated or you can keep it, and then you're obligated. And in fact, it could be a license for 5 years with an option to renew, and the licensee gets the option to renew. But if the debtor is the licensee, then there can be restrictions on whether it can be assumed and assigned, because it's typically, if it's a non-exclusive license, it's not a property right, it's a personal right. So that could be not allowed to be assumed. So intellectual property rights are tricky. We have to really kind of go through and analyze each event, each contract, and each party, and see what can happen. Even though I think it's important in this process, even though you can't, the code may say you can't do this, or the case law say you can't assume or sign it, that's just a point for negotiation. So you may lose that negotiation, but you shouldn't just give up on it, and you might be able to still get it under new terms.
That's an interesting thought. Matt, there's a sale that has made a whole bunch of news recently. In 23andMe is out there, and they filed bankruptcy, and there's a whole bunch of personally identifiable information at issue in that case. Can you talk to us about the risks of having personally identifiable information for a debtor, and when you go to sell it, what has to be done, and how that entire process works to protect the people whose information the debtor might have?
Yes. So I'd say the 23andMe case is, when you're talking personally identifiable information, I don't think it gets any more personally identifiable than your own DNA. right? I mean, that's
Right.
a little deeper than just your driver's license number or your social security card, right? It's the essence of you. So that one's interesting. And I think the sort of standards for selling PII are why the 23andMe case is interesting. So there's a section of the bankruptcy, well, there's a section of 363 that deals specifically with selling personally identifiable information, and in most cases requires the appointment of, I think they call it consumer privacy ombudsman under section 332 of the bankruptcy code. And so the ombudsman's job is to look at the debtor's pre-petition privacy policy, if it regularly collected PII from folks, and then chime into the court on, hey, is this sale going to violate that policy? Is there a loophole that the sale could be done through? Are there restrictions that maybe should be put on the sale if it is possible and approved? That sort of thing. So the best sort of state court analog I came up with is the ombudsman is like the guardian ad litem for all the people whose privacy is there, right? Because most of those people aren't even creditors or noticed in the bankruptcy case. They're not owed money, and they really don't have a claim. But their personal information is potentially being sold. So the issue with the 23andMe case is the privacy policy that they had allowed the sale of all that data. And so it's not an issue where, hey, we're collecting all this stuff and we're never going to do anything with it and we won't sell it to any other parties. It specifically allowed the sale of data, and specifically in the context of a bankruptcy proceeding. And so there's multiple parties that have sort of chimed in. There's a party who is a potential buyer, or was the buyer if it was approved. I don't know what the current status is. But the FTC chimed in, basically said, look, we don't dispute that their privacy policy allows the data to be transferred, but we want assurances and a restriction on the transfer that the buyer is going to continue to comply with that policy. Because otherwise you're changing what parties provided their information for. And an interesting issue too is there's this push to like withdraw your information from the 23andMe database. And I don't know if those people just don't understand how databases and the internet works. Like, it's there, right? It's part of the database. And so withdrawing it, I don't know if that gets you anywhere. But it's an interesting issue. I would say most of the time, or most of the sales I've been involved in really don't involve PII, so it's a relatively unique issue. But because it's unique, you do need to pay attention to it if that's part of what's being sold.
I think it comes up a lot when you're dealing in the healthcare arena. And I know I've seen it a lot in the sale of various healthcare organizations.
Yeah.
Ashley, what happens if you get a sale order, okay? And you know, Eric said a few minutes ago, nothing is really done until the money is in the debtor's pocket, right? Or the debtor's bank account. What if somebody appeals the sale order? How does that impact the entire process?
Yeah, so appeals of the sale order are interesting. Generally speaking, courts can waive the automatic 14-day stay period as part of the 363 sale order. And where that is waived, it makes the sale effective immediately upon entry of the sale order. So where a party does actually want to appeal the sale order, they need to take immediate steps to try to seek a stay of the sale order. Usually after the sale order is entered, there are things happening very quickly. You know, contracts are transitioning over, employees are transitioning over. All of these things would happen really quickly without that stay. And it could cause huge issues if somebody tried to have a completed sale where it has been closed, if they're trying to unwind that. So, first step is get a stay pending appeal. If the party appealing does not do that, it is likely that the appeal would be deemed to be statutorily moot. So, that's really the first step. And then if they are able to get a stay pending the appeal process, that could lead to other issues in the case, because those cases are typically dependent upon DIT funding and, the sale timelines in the case and the timelines approved by the DIT lender. So, all of these things need to be considered when determining whether the stay should be granted and whether the appeal can go forward and a sale could be potentially unwound. But usually a sale would not be unwound on good faith grounds if a stay is not obtained.
I know we are very close to being out of time, but I'm curious about, a 20 or 30-second response from each of you on one particular final question, and that is, a number of years ago we saw a bunch of cases where 363 motions, and you still see them occasionally now, get filed on the day or the day after the case is filed. There was a particular car company that I think went through an entire bankruptcy process in like 30 or 60 days, a sale process. And there's been a bunch of interesting thoughts about, do you have a truncated and expedited sale process right at the beginning of the case versus, letting it go, run its course and do the sale as part of a Chapter 11 plan. And I'm just curious on, each of you, maybe 20, 30 seconds thoughts on the benefits, pros and cons of that process, and then we're going to wrap up. Matt, you want to go first? We'll go alphabetically.
The only thing I would say is be prepared to battle with the U.S. Trustee's office on that issue. They don't like them.
And by like them, you mean the expedited sale process?
The expedited sale process, they especially if you're selling essentially the whole company, UST tends to view that as, they call it a sub rosa plan, which to me sounds very devious. Just the Latin phrase makes it sound dirty. And so you're going to have to battle with the UST on that. I think most judges I've seen, when they're dealing with that issue, tend to give short shrift to the U.S. Trustee's position. If that's the best thing for the debtor, is to have that quick sale and get the sale approved. So, and I think somebody else may mention this too. I think there's some benefits to a 363 sale that you maybe don't necessarily get if it's a plan, like a sale as a result of a confirmed plan. So there's that aspect as well.
Thanks. Eric, you want to chime in on this?
Be prepared. It's an emergency. So it's an emergency. So prepare for the emergency. Pre-market, follow your process, your corporate process, right? You have to still go through the corporate process, getting your board approvals, and the board's done the due diligence. Go to your secured creditor, make sure they're on board. They probably are the one driving the emergency, but get your constituents in line. Let the U.S. trustee know in advance. Don't file the motion and then go, hey, sorry, it was a surprise. And also know your judge, because some judges don't like them at all. So you better be prepared to answer all those tough questions. But I would be prepared and start the best thing is start the marketing process early and outline the emergency, why it needs to happen. You need that.
Ashley, any thoughts?
Yeah, I'll jump on Eric's point. I think the most important thing is if you are seeking a quick process is once you get all the parties aligned, there needs to be an understanding that usually the DIP lender and any stocking horse purchaser are usually trying to get the process done as quickly as possible. This is a company that could have, been in a close to free fall into bankruptcy. Funding could be limited. So really explaining what the emergency is in your motion and then being prepared both at the bidding procedures hearing phase and at any sale hearing. Make sure those declarations are in order, make sure witnesses are prepared to provide adequate testimony for why things happened the way they were, how the marketing process was done, what interest you received, and why ultimately this is the highest and best offer that the debtor and the debtor's estates and stakeholders are going to get for these assets.
Thank you. Panelists, thank you for participating. We appreciate everybody that's viewing this. We appreciate your time and hope you'll join us for the next episode of our series. Thanks.
Thank you.